Today we are going to discuss about the exemptions provided under Section 8 of the Right to Information Act 2005. The Right to Information Act 2005 provides various rights to citizens of India, though they are not absolute, and Section 8 provides restriction on which some of the information shall be withheld by the authorities. As we all know, right to information is a constitutional right. However, it is not an absolute right. This is subject to other constitutional rights like right to privacy as emphasized under Article 21 of the Constitution of India. Therefore, the RTI Act states certain circumstances under which the information cannot be disclosed by the public information officer. Now we move on to Section 8, which provides 10 types of information which cannot be disclosed. Section 9 describes the ground of rejection of information that infringes copyright. Section 10 talks about severability of information, where certain part of information can be disclosed and remaining part of the information cannot be disclosed. However, Section 8 subclause 2 provides that information exempted under Section 8 subsection 1 or Official Secrets Act 1923 can be disclosed if public interest in disclosure outweighs the harm to the protected interest. Furthermore, Section 8 subclause 3 provides that information which is exempted from disclosure under subsection clause 1 would cease to be exempted from disclosure if 20 years have lapsed after the occurrence of the said incident to which the information is related. Let's have a look on Section 3 of the RTI Act, which gives every citizen the right to information held or under the control of public authority. The rationale behind the implementation of Section 3 of the RTI Act is to bring transparency and accountability in the governance by providing access to information under the control of public authorities. The Honorable Supreme Court held that when Section 8 exempts certain information from being disclosed, it should not be considered to be after on the right to information, but as an equally important provision protecting other public interests essential for fulfillment and preservation of democratic ideals. The following observation was made by the court. Some high courts have held that Section 8 of the RTI Act is in the nature of exemptions to Section 3, which empower the citizens with the right to information, which is a derivative from the freedom of speech, and that therefore Section 8 should be constituted strictly, literally and narrowly. Probing further, we see that subsection A of Section 8 talks about the information which would prejudicially affect first, the sovereignty and integrity of India; second, the security of the state; third, strategic, scientific or economic interest of the state; fourth, relation with foreign state; fifth, lead to incitement of an offence. So, what this implies is that a public information officer has no obligation to disclose the information if it pertains to the above mentioned clauses which will endanger the security and integrity of India. Subclause B of Section 8 provides that such information shall not be disclosed which has been expressly forbidden to be published by any court of law or tribunal, or the disclosure of which may constitute contempt of court. Subsection C of Section 8 provides that such information shall not be disclosed if it would cause a breach of privilege of Parliament or state legislature. Article 105 of the Constitution of India is one of such privilege enshrined in our Constitution and also enjoys protection under subclause C of Section 8 subclause 1. Subclause D of Section 8 subclause 1 exempts the information which, if disclosed, would harm the competitive position of a third party. Here the information includes commercial, confidence, trade, secrets or intellectual property. Let's look at the case which is quite relevant for the purpose, is that of Union Public Service Commission versus Central Information Commission, where Delhi High Court rejected the contention raised by UPSC that information sought was in the nature of crucial secrets and constituted intellectual property of UPSC within the meaning of Section 8 subclause 1 subclause D of the RTI Act. In the instant case, the court further directed the UPSC to disclose the model answer to the questions of the same examination. The court observed with respect to disclosure of model answers to the questions that though UPSC may have some rights over them, the disclosure would be in larger interest. The candidate have the right to know where they went wrong. Moving further, exemption we see under subclause E of section 8, subclause 1, the use fiduciary used in that particular section means trust. A person who has the power and obligation to act for another under circumstances which require total trust, good faith and honesty. So, any information which is disclosed in position of trust shall not be disclosed and is exempted from disclosure. Let us look at one another instance in which any information received from a foreign government in confidence cannot be disclosed under section 8 subclause 1 subclause E. In case of Arun Jaitley versus CBI, the appellant sought information related to freezing and defreezing of bank accounts of Ottavio Quattrochi and others. The CBI claimed exemptions on the ground that communication with other external agencies which are cooperating in the investigation and hence exempted from disclosure under section 8 subclause 1 subclause E. Disclosure of information endangering life and physical safety shall be exempted from disclosure under section 8 subclause 1 subclause G. Let's look at the case of Kuldeep Kumar versus Commissioner of Police. The appellant sought the date-wise details of each and every investigational step undertaken by police to examine the suspects. The information on the ground that the confidentiality of the information received by the police may even endanger the physical safety of those pre-examined by public authorities. Clause H of subsection 1 of section 8 exempts from disclosure of information which would impede the process of investigation or apprehension or prosecution of any offenders. Any information relating to police investigation is exempted from disclosure under this provision where the investigation is going on and disclosure of such information is likely to adversely affect the process of investigation. When we probe further two exemption clauses, we see clause I of subsection 1 of section 1 provides that cabinet papers including records of deliberations of council of members, secretaries and other officers. This exemption has been provided in larger interest as a matter of public policy. However, there is no absolute exemption on such information. The legislature has made balancing attempts as decision of council of members, the reasons thereof and materials on which of such decisions were taken shall be made public after the decision has been taken and matter is complete. Under subsection J of subclause 1 of section 8 relates to personal information, the disclosure of which has no relationship to any public authority shall not be disclosed if it intrudes the privacy of individual. The information of following nature comes under the category of: first, the information which is personal in nature and which has no relationship to any public activity or interest. Second, the information which is personal in nature and which would cause unwarranted invasion of privacy of the individual. When we probe further into exemption into subsection 2 of section 8, which serves as the balancing provision which casts an obligatory discretion upon the public authority. It confirms that a public authority may allow access to public information if public interest in disclosure outweighs the harm to protect interest. Thus, any information which is exempted under Official Secrets Act 1923 or any of the exemption permissible in accordance with subsection 8 subclause 1 may be disclosed in larger public interest, and if public interest in disclosure outweighs the harm to the protected interest. Subsection 3 of section 8 is also an exception to the provisions of exemption as enumerated under section 8 subclause 1. It requires furnishing of information available to public authority after the lapse of 20 years, even if such information was exempted from disclosure under subsection 1 of section 8, exempting clauses A, C and I of this subsection. Thus, after the Right to Information Act was enacted in the year 2005, much of the information has been made available to public by public authorities, which was a distant dream before this act came into existence. But the sad part is that many RTI activists have been murdered in different parts of the country. Most of those killed were investigating irregularities in the sectors such as lands, elections and mining, where the corruption is rampant. Civil society organizations are now demanding that the government take concrete steps to protect the lives of such individuals. It is likely that the laws for protection of whistleblowers shall be necessary for the present day scenario. Hope you received a good idea of the information about Right to Information Act. See you soon. Thank you.